of the Petroleum, Oil and Gas Corporation of South Africa, SOC Limited's complaint against the Transnet National Ports Authority, which is the division of Transnet SOC Limited, in terms of Section 31 of the Petroleum Pipelines Act 2003. The Petroleum, Oil and Gas Corporation of South Africa, SOC Limited, is PetroSA for short, and the Transnet National Ports Authority is TNPA for short. May we then proceed, Madam Tua and your team, to present. I'm just giving you 3 minutes to do the presentation, because you need to take the matter as read. Over to you, Madam Tua.
Thank you, Chair. In the absence of the initiator, Mr. Untit is available to introduce the matter. Just to summarize what the requested investigation will be on, and the highlights of what we're requesting the members to approve. Thank you, Mr. Untit. Through you, Chair.
Morning, Chair and members. In short, a complaint in terms of Section 31 of the Act, and we have, as staff, assessed the matter. In the document, the background is provided in terms of that, and some initial problems in terms of confidentiality and sharing of information, which was resolved. Applicable law, and that I take as being stated there, and therefore maybe want to just make a few comments. The brief history for the members that's not maybe newer or not familiar with the context and how the operation is working there. Adding one comment that this facility dates back to the commissioning of the Mossgas gas project at the time, Netta PetroSA refinery, and converted back to TNPA as the owner. The basis of the complaint, as I said, Section 31. We've assessed that. We as a team, with the input of LAS, is satisfied that this is a proper complaint, if I can put it that way. May I add that there's no legal proceedings already been happening here, which was a lesson learned on the Transnet complaint that we still will be finalizing too. So that has been checked up front. And I think in principle it relates to tariff charge and how that should be done. I think that's the crux of the matter. We've given the details there. Maybe just one comment. In the application, PetroSA claims that there was never a tariff approved, but you will see in the document in 7.6, although there was some challenges initially to do approve it, it wasn't approved, reapplied for, and TNPA having some issues, if I may use that word, with the decision, but not such challenging it. That is stated what was approved, and now I think the dispute between the two parties is basically at the heart of this. We did list the challenges there, which included that this shouldn't be known, but as the members has now ruled, this matter is now, the fact that there is a complaint is a regulatory matter that could be discussed. My last comment before the recommendation is maybe Section 10, the motivation. There's definitely in staff's view a need to interrogate some of the matters raised here, which was also prevalent at the time of the actual tariff application, and maybe the tariff colleagues will assist me if there's questions post the introduction. And therefore the recommendation to the Petroleum Pipeline Subcommittee is to approve it, but maybe I've forgotten the investigation plan. Maybe just two comments, one comment on that before I finalize, is it's a multidisciplinary team. It's tariffs, it is legal services and PLC taking the lead on this matter. The plan is there, and we're effectively at step 5 in the time or the investigation plan as listed by the committee considering this and deciding on it. Therefore, the recommendation to approve the initiation of the investigation in terms of Section 31(1)(c) of the Petroleum Pipelines Act, the complaint lodged by PetroSA against TMPA, with its alleged failure to abide by the tariff set and approved by NERSA as a result of the 15-year agreement entered between the parties, and then to also approve the investigation plan. Sorry, Chair, if I've over my 3 minutes, but thank you.
Yeah, you went over your 3 minutes. Next time, please stay within that. I would just like to also state that it would have assisted if you also categorically stated that this matter is within the purview or the jurisdiction of the regulator to investigate Hengi in terms of the dispute resolution, mediation, and arbitration process that has been since established, because we in the last financial year we had that procedure approved by the energy regulator, which you are going to follow. So please ensure that the issue of jurisdiction is clearly and categorically stated to move on. So without any further ado, I would like to take this opportunity then to give members a chance to ask questions, comment, as well as provide guidance. By show of hands, members. Madam Maseti, and then followed by Mr. Sibanda, may come to the fore.
Thank you, Chairperson, for the opportunity. Chairperson, I would like to, and maybe this is for clarification, but also for the process going forward. The investigation that we're looking at here is the investigation pursuant to a complaint received. It's not an investigation initiated by NERSA out of its own accord. So we've got to also be very specific in terms of the sections of the Act, whether Section 4C and Section 31(1) are applicable together, or it is only Section 31 sub 1 that is applicable to this matter because it is a complaint received. It is not a matter initiated by NERSA, because Section 4C talks about instances when the regulator seeks to inquire and it will initiate such an inquiry or investigation out of its own accord. So we need to just draw a distinction there and provide the right context when the regulator has to exercise its powers. Which section of the law will the regulator invoke under such circumstances? So I would like that clarification first in terms of our own power, so that we invoke them appropriately, so that we don't say we're doing this in terms of Section 4C as well as Section 31(1). We must be very clear, and that also goes to that issue of jurisdiction, so that we don't combine the two. We are very clear what powers we are invoking. The second thing, Chairperson, that I would like to raise is again on the process. Whether when we receive complaints, do we need to prepare initiation reports like we will do when we're seeking approval that we initiate our own investigations. And that step of preparing initiation or asking for approval of initiation of investigation through a complaint, is it something that is contemplated in Section 31? If the regulator, in terms of Section 31(1), receives a complaint on a matter that the regulator has powers to investigate, should the regulator just go into the investigation because if it says we must investigate, or should the regulator now say, even if that section says we must investigate that complaint, the regulator must now first say, let's go and seek approval to initiate an investigation into this complaint by now bringing a submission of this nature? So we need to be very clear there, Chairperson, whether in all cases we will always have an initiation report on investigation of complaints. So I wanted to draw that distinction deliberately. And if then the answer is yes, we must always first have initiation reports, even if it's a complaint that we must investigate. Is that an efficient way of conducting investigations? If then we find that it is a necessary step to first initiate, what are we doing it for? Are we doing it because we want to confirm jurisdiction, something that the senior officials should do? Are we doing it because we want approval that we must investigate that complaint? I'm just not understanding the purpose of the initiation of the investigation for purposes of complaints received. If Section 31 says we must investigate those allegations, if then there seem to be merits to those allegations. So if then we find that it's a necessary step, maybe from a legal point of view, and we explain what is the reason, we say it's a necessary step that we first have initiation report, then I would suggest that we may also have to find a way of including efficiencies there. RSU has already assisted in terms of the standing instructions in the GAR division, but not on complaints received, but on investigations initiated by the regulator, where we now say we intend to initiate this. And the caution is that we don't want to be found to be exercising or abusing our powers of initiating. So we want to then bring it to maybe the committee, and so that the committee can see the grounds for the suspicion on the conduct that we see. So if then we find that we have made our case on suspicion that there could be a contravention or a breach of license conditions, therefore this is our basis of then us wanting to initiate. So and then we state what are those circumstances where we will be able to initiate. So RSU has assisted with that, and I will then say perhaps a similar process must be considered here so that we can make sure that we add efficiencies in our processes. So that is the second issue, Chairperson. The third one, for me, I think we did not clarify exactly the essence of the complaint here. I was struggling to understand what exactly is the issue here. Is the issue that in the way that you now articulate the complaint, it has been brought to you very raw, very broad, but you need to now say what exactly are they complaining about, and whether what they are complaining about falls squarely within our powers. So here I see sentences, I think they take the language of what the complainant has put, the same as the complainant, without understanding and putting it in the way that we understand is the issue here of dispute. So is the issue of dispute is the issue of dispute that TNPA is probably charging a tariff that is above that which is approved by NERSA. That is not coming out here. All that is said in general terms. TNPA is not charging tariffs that are approved by NERSA. What does that mean? Does it mean that they're not, in some way, there's another sentence that says it is not, it seems to indicate that there was no tariff that was approved, which is the one that TNPA is charging. So I was not sure what exactly is the issue here. Here's the maximum tariff approved by NERSA. Are we now saying that TNPA has gone beyond that maximum tariff approved by the regulator? Is that the essence of the dispute here? And that is not coming out clearly. And there are two paragraphs that are not really explaining it. Paragraph 4.3, for instance, and then the also the preceding paragraphs under 4 there on the background. So there's a need there, because on the background you state exactly what you understand to be the issue that is brought to you, and that is not coming out clearly. And then Chairperson, lastly, I just wanted to understand the extent of our powers to interfere with the contracts entered between two parties here, being Petro SA and TNPA, the 15-year lease agreement. And I would understand that lease agreement, indeed, it is a lease agreement that is governed by two pieces of legislation, because it has to do with the operations in the ports. So the terms of that lease agreement are governed, perhaps insofar as tariffs are concerned and the operation of the infrastructure is concerned, subject to the PPA. And I am sure that the Ports Act is also applicable. Now, we've got to be very careful in terms of the extent of our intervention in the terms of that agreement, of which terms of the agreement Petro SA is a party to that. And now Petro SA comes back and say the terms of this agreement are invalid. And now NERSA must declare that such an agreement is void. Now, I would like to understand the extent of our powers in intervening in such situations where we now have to declare contracts to be invalid, whether it was intended in the section that we rely on here. We did not explain the context of that section, first of all. We just say that there is this section in the law, in the PPA, but we don't explain what is the context of that section, what it seeks to do, and whether from our side, if we were to intervene under these circumstances on the contract that is also subjected to another piece of legislation, how and to what extent can we intervene? So, Chairperson, for me, I just wanted to ask those 4 questions, because for me, without explaining those, I struggled to see how we justify our jurisdiction, where we can then say, this is our jurisdiction here. Our jurisdiction, we don't just find it on the basis of saying Section 31 allows us to investigate complaints. We must now say what part of Section 31. If the part of Section 31 talks about a tariff that exceeds the one approved by the regulator, then we must say so to say the situation here seems to suggest that TNPA is charging a tariff that is above that which is approved by the regulator. And how does it do that? But if then it is adding other costs that are related to the Ports Act activities, would you then say that those other costs, you now lump them into the tariff approved by the energy regulator? Is that not the possibility here of a situation that is happening? Because maybe the TNPA is entitled to other costs for the operations of the infrastructure in the ports. And then with our tariffs are intended to recover services, certain services, cost relating to services. So we need to also draw a distinction there, Chairperson, but I'm not understanding how this situation or the dispute is arising here for us to be able to establish jurisdiction. Thank you, Chair.
Thank you. Mr. Sibanda.
Thank you, Chairperson, and to the team as well. Chairperson, I do note the issues raised by Ms. Maseta around jurisdiction and whether the initiation of complaints that we have received do require to come here. But I'll focus on the submission as is for now. So if you go to paragraph 5.2, we talk about the rules that have to be complied with when a complainant lodges a complaint with us. However, I think what we need to then be doing is to indicate whether this particular complaint does comply with the specific rule and whether it has been submitted in accordance with the procedure set out in the rules. Specifically, I think for me, for instance, the rule talks about the fact that the complaint must be submitted within a particular period. So we need to then respond to that and indicate whether that was indeed the case, but also to then indicate the efforts that were made to resolve the dispute. So this information might be there, but I think we need to package it in a manner that then responds to the specific rule that we have quoted. And we actually need to quote the rule, by the way, because what we've done here is just to quote subsection 31(1) of the Act, but we need to specify exactly what the rule says and then indicate whether the complainant complies with the rule before we entertain the complaint. And then regarding the investigation plan itself, on page 14 under resources, excuse me. So so TNPA has indicated that some of these activities fall under the ports regulator, but we've not identified the ports regulator as one of the stakeholders that we need to consult with. Under paragraph 3.1, we've mentioned TNPA, PPS, MSO, DMRE, and DOT. To my mind, DOT would be a different entity to the post regulator. So perhaps we just need to then indicate or include the post regulator. But also, I'm assuming that colleagues do know exactly where to go within these institutions, so especially DOT, so that we don't spend a lot of time, being, sent from pillar to post, trying to find out who should we contact, and also the type of information that we are requiring from these institutions. I think it's important to have that ready so that we know exactly what information we require from them. And then regarding the investigation team, yes, it is a multidisciplinary team, but I don't see a dispute resolution person or specialist. I'm assuming we do have such skills within PPR, but it will be useful to have a dispute resolution person as part of the team. And then yeah, I think I'll stop here, Chairperson. Thank you.
Thank you, Mr. Sibanda. Mr. Kumede.
Thanks, Chairperson. Good morning to you and members and colleagues. Just a couple of questions for me for clarity from Martin. I'm quite unclear with this complaint, I must admit, in the sense that, to me, the question that keeps ringing in my head is that ordinarily with these CBMs and SPMs and whatever, they tend to be owned and operated by the in the case, for instance, the one in Durban is owned by the industry. It is on TNPA land, but it is owned and operated by industry. The question therefore was, I'd like to understand that the facilities in Mossel Bay, are they owned by TNPA? I guess what I'm trying to understand is TNPA both a landlord in this case, as well as the owner of the facilities? But yeah, so that is the first question. From the report, it seems that Petro SA, through a third party, operates the facility. Now, I would have assumed that if Petro SA, via a third party, is the operator, then it would have been granted an operating license. And I would have assumed that it is the owner, it is the operator that gets a tariff, if I can be clarified then. But if the operating license was granted to TNPA, I'd like to understand on what basis was that operating license granted to TNPA. TNPA is not the operator. And also, I just wanted to then maybe get an understanding here what the issues are, in the sense that, is TNPA charging wharfage as well as rental? I guess wharfage, I just look at all of this in terms of cargo dues and all of those types of things, but specifically wharfage, I would assume in terms of its own specific act, like a surcharge. Is it charging that, but also charging rental of these facilities in terms of the approved tariffs, or maybe even above the approved tariffs? So for me, that is what is missing, even if there is an explanation, for instance, in terms of that breakdown of paragraph 7.6. Is that rental? Is that rental plus surcharges, all of those surcharges which are called wharfage and all of that? How are these broken up? But I guess for me, the biggest issue is that I just want to know who owns these facilities, these SPMs and all of it. Are they owned? Yes, they may be on TNPA land, but are they owned by TNPA? Number one. Number two, who then operates? And who holds the operating license? Therefore, who is actually the one that has been given a tariff? Is it the operator, or is it the owner, or is it because TNPA is both the operator and owner, and, but I guess not just both, but also a landlord? Thanks.
Thank you very much, members, for your inputs, comments, as well as guidance provided. I take some of the matters here as matters of guidance. In terms of section 4, there isn't really a coverage of section 4, but maybe we should be able to, the team, if you can just enhance by making sure that any other related areas in terms of investigations are clearly indicated as not being applicable, and with section 31 being applicable, with these other costs that are added being tantamount to a tariff that is higher than that which is set by the regulator. And therefore the need to investigate, to look, as Madam Massetti also mentioned, on the issue of those added costs as to under are they justifiable? Where they fall under, are they really not tantamount to the increase to being additional to the tariff, to the extent that actually the tariff is well above what the regulator had approved. Also want to talk to the issues of the extent of powers to interfere with the contracts entered between parties. Section 34(1) is very clear on this matter in terms of the prohibition of agreements that are contrary to the Act, where the agreement may not contravene any provision of the Act, license granted by the authority, or conditions attached to a license granted by the authority, which will then be able to talk to the issue of the tariff that the regulator would have put there. And I think that some of the issues, they pertain to actually the articulation, to articulate and put it very succinctly that there is jurisdiction in this regard, and therefore the consultations will then include the other players like DOT, DPE, as Mr. Sibanda alluded to, as well as PRSA. In terms of the dispute resolution specialists, when we sometimes we talk of PLC, but the full name is not just licensing, it's also dispute resolution as well as compliance monitoring and enforcement. So the person coming within the department is our team specialist. As to the competency or level of depth and understanding, that is a different case, which I think that such events also assist to hone their skills in this regard. And I think that we need to also look into that in terms of skills development and for the involved personnel, not only here, but also applicable to other divisions like gas as well as electricity regulation. I also take it that when it comes to the need to take this for approval to proceed with the initiation of an investigation into such complaints as provided for in terms of section 31, I think let us not be seen to be maybe talking differently to what we had directed previously, to say that we need to do that to ensure that there is no situation where we're misconstrued to be abusing our power by way of victimizing or threatening any licensee by way of investigating them. Hence, the need to have this step. As to the issue that we should separate then is the one of efficiency, where we need to look at whether this should be done by way of standing instructions or not, so that this can be done speedily and approved maybe at the level of the FTRM consent or primarily responsible or not. So that for me is what is key in terms of the step in initiating such, because at the same time you don't want to expend resources on something that has not been approved in a proper manner, with official approved, in other words, by the regulator. I take it then that Mr. Untit and the team, you will then respond very clearly on the rest of the issues that are direct questions. For example, looking at the ownership and who the landlord is. And I think part of the investigation will also be able to clarify as to what lies within the TNPA as a landlord vis-a-vis what is part of the tariff. Over to you then, Mr. Untit and the team. Thank you.
Thank you, Chair. And then.
Sorry, Mr. Untid, one last thing that I should have mentioned to you is the importance of putting that resolution, that dispute resolution procedure. It's important because then that also indicates that you are on the first steps and you are duly following it. Because remember, also gave rise to this to the refinement of the procedure, which then this is the procedure that you are now following. And I think that should come out very clear, and if need be, even attach the procedure itself in your as part of an enhancement. You may then respond, Mr. Untid.
Yeah, thank you, Chair. Maybe just on the last one, you are correct that we identified lessons learned, but the formal process to amend that is still in progress. So it hasn't been, but there was definitely some lessons learned, as you clearly indicated, of which we were trying to really implement here. For example, ask the question, has this been part of a legal process? Because that one we realized was a problem when we looked at the Transnet matter, because that court procedures, I wouldn't say interfered, but that wasn't catered for. So what we need to then do is just expedite the formal changes to the procedure, but as you correctly indicated, we are now following that. Then maybe working backwards on the matters I can respond to, because our department acted on the legal guidance we got, but let me work backwards. Mr. Kumedi's question in terms of that. So it's really one of those instances where historical matters dating back prior to both the Ports Act and the Petroleum Pipelines Act being gazetted. What's the complicating factor here? I'll answer your question about who's operating that, but this is important context. The actual marine buoys was constructed by PPS during that time of the building of the refinery. It was designed, it was to be integral to supplying them. They actually operated and maintained it initially. Then it reverted, and the date, I've made a note, we need to give the committee the date. The actual assets in terms of the loading part, the buoy, the supporting anchor up to the plim, the pipeline end manifold, that is owned by Transnet via TNPA as the landlord. So that's the first point. However, from the plim, I'm not sure what the depth of the water is there, 40 meters down, there is a pipeline running which is owned and operated by PetroSA in terms of a service level agreement. So that's the complication, where typically a marine loading facility and its auxiliary pipeline that would have landed somewhere on shore in a facility, here there's a split in terms of the ownership. So that's the complication. So TNPA owns the buoy. To PetroSA, including all their pipelines and their voorbuy facility, is a separate license. And I think that's at the heart of this complication. So who's operating? So PetroSA may be via this third party is operating the facilities, but the owner, the licensee, is in terms of the Petroleum Pipelines Act issued to the owner, and the owner is TNPA. They've provided proof at the time. If you ask the basis for the decision, and maybe we should be sharing that decision in terms of that. And this was a matter debated, and it's in the reasons for decision on the tariff, and maybe the tariff colleagues can say. So I'm not sure if I answered your question. the operation license is issued to TNPA for the actual NBN, CBN, because they are the due owner or duly the owners. While, however, it's connecting to other assets, which is then owned by another party, which is Petro SA, and that is where this split is. So there can't be an operating license for the operator. I'm not a legal person, but the way I was taught, the Gas Act is different. And the Petroleum Pipelines Act doesn't allow for the operation of that, but I'll have to be guided by the colleague. So your second question was rental plus other port facilities. Yes, it's duly split. That the port dues and cargoes, that is approved by the ports regulator. It's charged separately. It's not part of the agreement. It's an additional charge. Every ship comes in, that part is paid separately. So your question, the rental is the issue here as part of the contract. The cargo dues, that is an extra invoice separately paid outside the contract. I hope that answers your question. Mr. Sibanda, the jurisdiction you noted.
Just the, I think with also Mr. Kumede, if you can just maybe to state that a person with a operating license may not necessarily be physically operating at any point in time, because it could happen that they then strike a contract and an agency contract with a third party to then operate on their behalf. In terms of looking at who's holding the license or who's the licensee vis-a-vis who is actually operating, which can be an outsourced function. If I'm not mistaken, I think that should also come out very clear. Thank you. You may proceed. Oh, sorry, I see Mr. Kumede's hand is up.
Chairperson,
Just a follow-up on this.
Yeah, just a quick follow-up. You see, for me, the challenge comes if you read, for instance, paragraph 7.7 E, Roman numeral 5, that Petro SA receives no compensation for operatorship. See, the challenge with me, which I'm trying to understand with this contract, is that I can understand, for instance, I'm trying to premise it and benchmark with other pens in Durban, that you have the owners of the CDM, of the SPM, for instance, that they are the ones that own and operate that facility. And I've assumed that the operating license was granted to them. Yes, it's being done on TNPA land, and all of the other charges also they are being charged for those other charges, wharfage and all that. Now, the question I'm asking here is that in reference to that paragraph, to that statement, Petro SA receives no compensation for operatorship. So it seems to me that Petro SA is operating or has been operating this at its own cost. Yes, it may have subcontracted, so it pays somebody else to operate this, and yet the operating license is actually granted to TNPA, but TNPA does not provide that service, and yet it still charges a fee for that. To me, it sounds very complicated. Thanks.
Thanks, Mr. Kumede. I think that then even justifies the need for a proper investigation into this, so that one can get to the bottom of the issues that are at play. Madam Maseti, and then Mr. Untiti will proceed.
Thank you, Chairperson. Chairperson, is a follow-up on the question asked by Mr. Kumede. That question is important, Chairperson. At a very basic level, we need to understand what is going on about this cost. We can't say that we have this in the way that we're going to invoke our powers here without suspicion. We have that is a legal test. It's a bar when you have to look into investigations. And it is clearly stated by the Supreme Court of Appeal. It is clearly stated also in matters that went as far as the Constitutional Court, when public bodies, now even on initiation of reports, all of these regulators in the country, when they have to, first of all, establish whether there is suspicion and where that suspicion arises, Now, I'm not sure here, because if we say this dispute arises from a tariff that does not comply with that which is approved by the regulator, then part of this information says there are other activities that are regulated in terms of the Ports Act. This lease agreement in question, which then entails these other costs that PetroSA says we must say is unlawful. That agreement could be considering other costs, as Mr. Gumede has stated. I also stated those to say there may well be other costs that are not necessarily costs that should be in our tariff. But when TNPA now bills PetroSA in terms of the agreement, it will obviously have this part of the tariff as well as other costs that relate to services regulated in terms of the Ports Act, which PetroSA must pay. That will perhaps be in the billing, in the invoice. Now, what the colleagues are bringing here, I'm not explaining that aspect to say, how does this issue of tariff arises? Is it clearly stated that this is the tariff for these services under NERSA's jurisdiction, but that tariff is way above what the regulator approves? I'm not getting that. And for me, it becomes very difficult to even then, at the minimum, to then say, yes, there is an issue to investigate. It's something else to get other facts now, to get other clarification on this, but at least establish one thing. Are we talking about a situation where indeed this cost that they are complaining about is well within the tariff charged by NERSA?
Okay. No, it's fine then. Please, if you can just assist also, because I'm just looking at this matter now. We're going for 10 o'clock now, and we're still on the first issue. If you can just assist in terms of the timing when also making comments to run this meeting efficiently. I had alluded to the fact that this is the issue is that the way the costs are not so clear, they are tantamount to them being to the tariff being higher than what the regulator has said. And therefore, the need to then investigate so you can be able to delineate this cost. The investigation would serve to do exactly which the members are talking to, in my understanding. So, Mr. Untit, if you may just proceed, just talk to this briefly, please. Try to be very economic with time, please.
Yeah, thank you for the guidance, Chair. But then I humbly submit that we don't have all the facts to provide that. There's allegations made, and that needs to be tested. We don't have the invoices, we don't have the bills. I think in terms of our procedure, and maybe then that is another matter to discuss, and relating to efficiencies and how we do it, that the procedure should be differently in that. But I think we were asking the committee I'm not sure, go ahead, in terms of the procedure to now continue, to write now to the party, forward this to TNPA, because they haven't even received the allegation. They may be aware of it, but that. And as part of that process, we'll get the facts. It will have to be investigated, and then whether some of the claims are correct or not, and that. But I think maybe legal department, I think PPT, the initiator or the project team member is on leave, but I'm not sure if Ms. Sabaku can assist us there. I think she's the co. But in short, Chair, I think we want to just get the permission in terms of our procedure to proceed to ask all the questions that the members duly asked in terms of what is the bill, what is the invoice, and for us then to in detail analyze that. But in staff's view, there is reason or there is justification to dig or to investigate the matter and bring the facts then back to the committee. I can't do more than that. Maybe the legal colleagues need to assist us and or PPT if they want to add.
No, I think now is the right time for you to proceed to the issue of the investigation being, the dispute or the complaint being able to meet the rules and procedure requirement.
In short, it's not detailed. It's got some basic format requirements. Fill in this form, submit this, submit an affidavit. That we've checked and it meets it. Maybe where we made a mistake is in not stipulating, as I think Mr. Sibanda was requesting. That will enhance to be clear on that. But that checklist was done, and as staff we satisfied they've meet the requirements. Now we will be putting the information to the respondent. They will be bringing back more information to refute or give their side, and as part of the process, then we will also ask further documents, already some of the ones that the members listed in terms of the invoices, the bills, and to duly understand the matter. And then obviously we'll also do a site visit again. I think the previous time we were prevented by prevailing weather.
No, I think that suffices, Mr. Umtit. The main thing is in the enhance that paragraph by stating that it does meet the minimum requirements. If you can just state that in terms of us proceeding with the investigation therein. All these matters must be categorically stated and be said that they are following we are following the rules and procedures. And then this also would serve as the enhancement of the procedure that was approved, that is in place, because this becomes more like the first real test or first utilization of that procedure. Hence, because some of the things, as we've said earlier on, in terms of efficiency, even maybe the key steps, they can be dealt with outside of the meeting, such that when we come here, some of the things have already been clarified, and that will still require approval, so that it's also not deemed to be abuse of our powers. I will leave it at that. Just quickly deal with the other matters if there are any left. Please.
Yeah, I think the last comment, I think it was an oversight not listing Mr. Sibanda, the ports regulator as a key party.
Well, I've spoken to that. It should be included. Let's move on. What's the next thing?
I think there was a question about our powers, and there I'll have to be assisted from Ms. Masetti in terms of this. I'm not sure if Ms. Tlamini is in the meeting. And the section, and I think some of that is also just enhancements, as you correctly indicated, explicitly being section 4 don't apply. But I'm not sure if the legal colleagues can add. The others I can't, unless I've missed something. I haven't got any further clarity I can now provide, Chair.
Thank you. Members, as we have heard the responses, and there's an indication that the document is also going to be enhanced accordingly in line with the inputs and guidance provided. That then, taking that into consideration, I think if we move to the recommendation, which talk to the approval for the initiation of this investigation into the complaint that has been lodged by PetroSA regarding TNP's failure, alleged failure to abide by the tariff set or approved by NERSA as a result of a 15-year license or lease agreement entered between PetroSA and TNPA, and then also the investigation plan, which is attached as Annexure 1. By show of hands, members, if you support the approval? Thank you, Mr. Kumete. Thank you, Mr. Sbanda. I don't see Madam Simane, Madam Maseti.
I raised my hands.
Oh, sorry,
Raised my
thanks.
hand.
Yeah, okay, thanks, Madam Simane. Madam Maseti.
Chairperson, I will abstain. The questions have not been answered, including even just the clarification on section 31. Martin even stated it, but there was no effort of even answering that. So I feel like my input has not been taken into consideration. But I will abstain, Chairperson. You've got a majority. Thank you.
Okay, but before then, as I said, there must be some persuasion. I think that it is in order that we just quickly look at that, noting that the other members are supporting. In terms of section 31, that there is a suspicion enough that there is no compliance with the tariff that has been set by the regulator. That was my understanding. That there are charges which then, in terms of the of the contract, what they are being charged instead of the tariff that they are being charged is more, but it's not so clear as to whether there are other charges that are being included in the tariff, and therefore they need to zoom into the tariff, to zoom into the contract, to be able to delineate what is the tariff and what are additional charges that are coming as a result of the powers that have been imbued upon the landlord, being TNPA. That is my understanding, Madam Maseti. I don't know, maybe if that is clear enough to assist you in terms of taking a decision.
Thank you, Chairperson. Chairperson, I'll let it pass since it's an initiation of an investigation and given your explanation. But I think we need to do it in a much more efficient manner, and also I think we need to improve on the understanding and the summary of the essence of the complaint. I think that becomes very important for me. But also, Chairperson, just to request that RSU and legal services assist us in establishing whether this is supposed to be a legal step that comes to the committee insofar as section 31 of the PPA is concerned. That's my request, Chair. Thank you.
Thanks. That will be done. I also support the recommendation as put forth. Therefore, you've got your recommendation, Madam Chua and the team, but take to heart all the comments, the guidance that has been provided, and clearly indicate your responses as to these matters, because then they will also assist you in terms of the investigation itself. With that, we then proceed to the next item, which is item 6, which it's actually the prudency review report number 3 on assessing contracting strategy and risk allocation between Sunrise Energy and its contractors. I think it's just important to note that we are looking at also briefing skills that pertain to prudency reviews, because prudency, as we set the criteria for prudency in August of 2021, 2018, I mean, it then became important that we ensure that we do these high-level prudency reviews, but then there's from time to time there's a need to really deep dive into prudency reviews to ensure that all the costs that have been incurred are indeed prudent, and there's efficiency in whatever the licenses I'm embarking on, so that the tariffs that we set and in the other division, as well as the prices that are being set or approved, indeed what the customers ought to be paying. With that, then I'll just give you 3 minutes, Dr. Kolo, just to talk to the submission. Please take it as read.
Chair, if I may come in, Dr. Kolo is on leave due to family bereavement. Miss Agnes will lead the team to introduce the matter, and the team will support in terms of whatever questions come. Thank you.
Thank you very much. Over to you, Madam Kosi.
Thank you, Chair. Good morning, members and colleagues. The purpose of this report is to request PPS members to note the report 3 on assessing contracting strategy and risk allocation between Sunrise Energy and its contractors. This report provides preliminary work done on the report 3 about cost escalation due to unforeseen occurrences and risk allocation between the Sunrise and its contractors. At the time of drafting the report, there were limitations with information at hand. Hence, it had to focus on profiling the risk. The next step being undertaken is to examine the contracts in detail. The process being undertaken currently, including the information on Report 3, was shared with Sunrise Energy during the technical team meeting of 8 December 2022. Sunrise Energy did not raise any concern with the Report 3 on risk. The Report 3 also highlights that 2 of the contracts have a high level of risk. However, this exercise does not necessarily limit the scope of the analysis to those contracts, as the team has found out and demonstrated to Sunrise Energy that even the low-risk contracts can lead to imprudence. Although this submission makes reference to NESA team having questioned the approach followed by the consultant, since it was not explicit in the report that there is another phase of the analysis that is coming. This has since been clarified and it is not an issue anymore. The first draft of the full report to be submitted to NESA by 31st January 2023 will have updated version of Report 3 and all other reports. Therefore, it's requested that PPS notes the draft Report 3, which will be updated. The first draft of the full report containing all the deliverables is submitted to NESA by 31st January. Thank you, Chair.
Thank you very much, Madam Kosi. Members, you'll perhaps recall that there was a first prudence review that was intense, which was done on Transnet pipelines. And now this is a second one of this nature. And I must say that I found the team to be efficient in terms of working on some of the deliverables concurrently, so that they can move with speed and be able to conclude this investigation soon as we heard. There was also a steering committee meeting that was held the day before yesterday that looked into the next report that should come. And one of the things that was stressed was that we shouldn't only look at what was delivered efficiently, but we also need to look at whether there were any bells and whistles and gold plating that was made, in a way, be able to also benchmark both nationally and internationally in terms of looking at the efficiency of the investment, because we can still be deemed to have prudently spent funds, but on something that is may not necessarily be required. So this was just another point that will also be looked at as part of the improvement in terms of just looking at the prudence itself. I will leave it at that, members. Again, you will find that the next report will still be going back on some of these things, on some of these deliverables that are outlined on page 3 of 54, to talk to specific as new information emanates. There's also new information that is supposed to come up from Sunrise Energy by close of business today. I will leave it at that. Members, if you've got any questions, comments, or guidance to provide to the team, over to you, please, by show of hands. Mr. Sibanda, sir.
Thank you, Chair. Question of clarity, and thank you to the team. On the first part of the report that talks to conformity to the procurement policy or compliance with the licenses on procurement policy, I just need to be helped here in terms of the distinction between a contract that is classified as a discussion point where there are reasons for non-conformity or non-compliance, and one where there is outright non-compliance. I'm starting to get the gist of the difference here, because if a contract doesn't comply with a policy, it doesn't comply. Despite the reasons given, but also these and there are quite a number of these contracts where there are discussion points, and they needed to have been resolved in an in-person meeting that was scheduled for mid-November. But I'm not sure whether that meeting did take place. The report is not clear on that, and it will seem to me that that meeting is still outstanding. But I also wanted to check whether such contract can move from discussion point to non-compliance or non-conformity. The same applies to the part of the report that talks about the risk profile assessment, starting from page 41. So there's a lot of outstanding information, again, that was supposed to have been provided or clarity provided in the in-person meeting, and so the report is unable to make firm conclusions. And then, Chair, because there have been similar challenges in the past of outstanding information, so we will find ourselves with the reports that are unable to make firm conclusions, and it would help in the consolidated report, perhaps just to tabulate the issues that have been outstanding in each report and how those have been resolved, instead of us getting a consolidated report with track changes only. But for me, I would want to see how, starting from the first report, how the outstanding issues have been resolved, because it's quite easy for issues to fall through the cracks. So I would want to see that in the final or consolidated report. But yeah, I just noted that this report is unable to make firm conclusions because of the outstanding information and the meeting that I'm not too sure whether it did take place or not. Thank you, Chair.
Thank you very much, Mr. Sibanda. That is the only comment and with suggestions and as well as guidance. I just want to stress to the team, just to not necessarily something to respond to, but to implement the table of outstanding issues and how they've been resolved as we move from one report to the other. It's very important to have that, as it is a matter that was also raised in the steering committee, to make sure that we also learn and ensure that we improve in terms of conducting these prudence reviews. Two, also find how we can put the onus on the licensee to prove prudence where there is lack of information. That is also one issue that is linked to that. I would also say that, Mr. Sibanda, these are more of progress reports also, and with the refinement as we move from one report to the other. Where the matter is closed, the report should also indicate very clearly that such a matter has been closed and dealt with, and if there's a quantum that is linked to that imprudence, it should be duly indicated as such. The report was issued for an earlier date, as was also discussed, that this being a special meeting with the administrative challenges that led it not serving on the meeting of the 2nd of December. By the time the report was written, the meeting had not been held. The meeting has now been held, in my understanding. And then what has happened is that the team is also going the licensee requested extension to provide information, and that this is the information I was talking about earlier on, to say it is going to be provided by close of business today, following the face-to-face engagement with the team. But Madam Kosi, please talk directly to that if you've got further specifics on that, as well as the classification of compliance and non-compliance. If you can just talk to that, please.
Mr. Lukelo will assist on this, sir.
Mr. Lukelo, over to you, sir.
Thank you, Chair, and good morning to everyone. Not to maybe to the discussion point, yes, the meeting did happen. It was on the 21st and the 22nd at sunrise, and those points were discussed, and we got updated. Like this table was updated. The last update we have is 9 December, but as indicated, it will form part of the next report, just to indicate exactly now, has it moved to yes or no? Thank you, Chair.
Thank you. Mrs. Banda, I just want to check with you if you're happy with the responses.
I'm covered, Chair. Thanks.
If you're happy, sir, then thank you very much. Just like us then to move to the recommendation, which is to request the committee to note this report on which is the report number 3 on assessing contracting strategy and risk allocation between SARA's Energy and contractors, which is attached here to as annexure as Appendix 1. By show of hands, members, if you support the recommendation. Thank you, Mr. Kumete. Thank you, Madam Simane. Thank you, Mrs. Banda, and thank you, Madam Maseti. I also support the recommendation. This then concludes the substantive agenda items of the meeting of today. I would like to thank all the members of the public that have joined us through the various live streaming platforms, showing the interest in the work of the energy regulator. This is much appreciated. I would then also like to give my appreciation to echo my appreciation to the members for their pointed questions, which help to refine this submission and also improve the efficiency and effectiveness of the institution. Thanks a lot, members. Thanks also to management and staff. Then the meeting then will be